Welcome to Land Administration S'mores, where complex land issues meet campfire clarity. My name is Jack McKenna. I'm a geospatial consultant and land administration subject matter expert. We break down land rights, cadastral systems, geospatial tools, human rights, and property law into digestible bites, just like s'mores. From boundary disputes to land grabs, titling systems to tenure security, we're here to inform, ignite debate, and inspire change. Whether you're a professional, an academic, a student, a policymaker, or simply land curious, grab a virtual marshmallow and join the conversation. Today's conversation is about the UK Privy Council case, Chitolie versus NHC, the St. Lucia Housing Authority. Rewarding dust with gold. How a cancelled, defunct land parcel was rewarded with surveyed land by His Majesty's Privy Council. That was the UK Privy Council case, UKPC 2023-43 from St. Lucia. And it was based on the published book by Vance Chitolie, The Privy Council Judgment That Betrayed Justice, Imported Doctrine over Enacted Law, available on Amazon. And I'm Jack McKenna with Land Data Plus. Chitolie were the appellants versus St. Lucia National Housing Authority, NHC, the respondent. His Majesty's Privy Council delivered a judgment that undermines the rule of law, erodes parliamentary sovereignty, substitutes enacted statute with unlegislated Australian doctrine, violates internationally recognized human rights principles, disregards statutory property rights, defies geographic reality, and relies upon a deed linked to a parcel cancelled and extinguished more than 11 years earlier, and created a new case for the respondent. How can the highest appellate court extinguish statutory rights through legal fiction and unlegislated doctrine while claiming fidelity to the rule of law? The respondent's claim. The respondent, the St. Lucia Housing Authority, claimed possession of Block 1020B, parcel number 227, a parcel that had been long cancelled, expunged, and rendered legally extinct over 11 years ago at the Land Registry. A claim for possession of a non-existent parcel. The core issue. The respondent's cancelled and defunct land parcel was treated as legally effective by the UKPC judgment and rewarded with surveyed land and costs, despite having no existence in law, on the register, or on the ground. How can the highest court deliver judgment upon a legally extinguished parcel? This is the respondent's cancelled, defunct, expunged legal corpse for parcel 1020B 227. The legal status of parcel 227. It was cancelled by mutation over 11 years ago. It's undemarcated and unsurveyed. No geographic or legal boundaries. It's legally extinct under the Land Registration Act. Yet, the UKPC judgment conferred proprietary effect upon the non-existent parcel. Judicial contradiction. Despite its extinction, the Privy Council judgment treated the cancelled parcel as capable of generating title, defeating surveyed and court-ordered parcels protected by statute. The UKPC judgment rewarded the non-existent parcel with surveyed land as though non-existence can generate proprietary rights. Geographic impossibility, fusing west with east. A cancelled parcel west of the ravine was fused with surveyed land east of the ravine, ignoring geography, the register, and statutory requirements. The UKPC judgment created a geographic impossibility, fusing west with east. The legal impossibility of title to a dead parcel. Title must attach to a defined and legally existing parcel. Yet, the UKPC judgment awarded surveyed land to the respondent on the basis of a phantom deed tied to a non-existent parcel. Judgment for the non-existent. Nemo dat quod non habet. One cannot give what one does not have. Yet the UKPC judgment granted the respondent surveyed land on the footing of a non-existent parcel. Judgment alteration without explanation. The circulated draft judgment was materially altered by the UKPC without notice to the appellants, without reasons, and without any formal explanation. The absence of transparency raises profound constitutional concerns as to how, why, and by whom the judgment was altered. The circulated draft preserved a clear distinction between the respondent's defunct parcel and the appellant's surveyed lands east of the ravine. The final promulgated judgment removed that distinction, and the effect was profound. The final judgment resurrected a cancelled parcel. It created a legal fiction of continuity for a legal extinguished parcel, based the judgment upon a deed to a parcel long cancelled and defunct, and effectively predetermined the dismissal of the appellant's appeal. Justice was altered by deletion, not determined by law. A court of final appeal became a court of silent alteration. Judgment in disarray. The judgment was not delivered unanimously by the full panel of 5 judges, but instead proceeded as a majority decision of 3. 2 senior judges, apparently unwilling to endorse the reasoning, did not join the majority. The result raises profound concerns that judicial overreach was permitted to undermine constitutional order, parliamentary sovereignty, and the rule of law itself. If judges of the highest appellate court could not reach consensus on the reasoning, should the judgment itself now face constitutional scrutiny? Systemic impact of the judgment. The UKPC decision reflects a shift from enacted law to judge-made narrative. It undermines parliamentary sovereignty and erodes legal certainty. It amounts to rule by judicial assertion rather than by statute. Constitutional concern. Judicial overreach undermines parliamentary sovereignty and the rule of law across the Commonwealth, including the United Kingdom. The judgment of His Majesty's Privy Council constitutes an instance of judicial overreach that overrides enacted statute, undermines parliamentary sovereignty, and erodes the integrity of the rule of law. Human rights dimension. The UKPC judgment constitutes an arbitrary deprivation of property, contrary to Article 17 of the Universal Declaration of Human Rights. The judgment of His Majesty's Privy Council stands in violation of fundamental and internationally recognized human rights norms. Unavoidable questions. Is His Majesty's Privy Council above the law or bound by it? Can constitutional legitimacy survive where the highest court departs from enacted law and Parliament's sovereign authority? Will the Crown intervene to remedy the judicial overreach and reaffirm the rule of law? Will the Crown intervene to address the human rights violation arising from the judgment of His Majesty's Privy Council? If all 5 judges could not unite behind the reasoning, can a divided final court legitimately extinguish statutory rights through judicial substitution rather than enacted law? Conclusion. This case exposes a fundamental breakdown in the rule of law. A UKPC judgment founded upon a legal void, a deed tied to a parcel cancelled, expunged, and extinguished for more than a decade. It rests upon a geographic impossibility by treating lands west of the ravine as if they were situated to the east. It rewarded surveyed land and costs for legal nothingness. It constitutes judicial overreach, undermines parliamentary sovereignty, erodes legal certainty, and violates fundamental human rights protections, most notably the prohibition against arbitrary deprivation of property. Can a divided final court delivering a non-unanimous judgment legitimately extinguish statutory rights through judicial substitution rather than enacted law? The closing statement. This matter raises profound questions as to whether enacted law can be displaced by judicial substitution, whether statutory rights can be extinguished by unlegislated doctrine, and whether constitutional safeguards remain meaningful when the highest court departs from the expressed will of Parliament. Magna Carta established the enduring principle that power must remain subject to law and scrutiny. No court, however high, can preserve public confidence if constitutional integrity, parliamentary sovereignty, and the rule of law are displaced by judicial substitution rather than enacted law. The unresolved question therefore remains, when judicial authority departs from enacted law, who safeguards the Constitution, the sovereignty of Parliament, and the rights of the people? Crucial question for St. Lucia. Will St. Lucia enforce a Privy Council judgment that arbitrarily deprives the appellants of their surveyed land through unlegislated Australian doctrine contrary to enacted law and in violation of international human rights norms? This moment calls upon St. Lucia to reaffirm its commitment to constitutional governance, parliamentary sovereignty, the rule of law, enacted statute, and its international human rights obligations. Thank you for your time and attention. This has been Jack McKenna of Land Data Plus. Thank you.